Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer, and this is the 5th video in our series entitled Dangerous Business Practices in a Seller's Market, and I am grateful to once again be joined by my friend
Paul Blumenstetter, Remax Integrity, designated broker owner.
So Paul, one of the things that I read frequently in the listing brokers offer instructions that are sometimes uploaded into the MLS as an attached document is the suggestion or instruction that a buyer make an offer, and in their offer they remove the paragraph from Form 21 entitled Information Verification. What do you think of that?
It is absolutely stunning to me how many listing brokers out there ask for that paragraph to be removed in their offer instructions, and even to the point of where they counter a buyer's offer that has it included and strikes it there. Listing brokers who ask for an information verification paragraph to be deleted or removed do not understand what that paragraph is doing. Listing brokers see that as a 10-day get-out-of-jail-free card for buyers, when in actuality it's a provision that was put into the purchase and sale agreements to not only protect but also benefit the sellers. And listing brokers just do not understand that provision at all.
So let's talk about why the information verification provision benefits the seller, because it does give the buyer a 10-day right. Boilerplate. It's not a 10 days that you can fill in a blank. It's 10 days boilerplate. That buyer has the right to terminate the agreement if, and here's why it's not a get-out-of-jail-free card. Buyer only has the right to terminate based on the information verification provision if buyer discovers a material inaccuracy in representations made by the seller. So this could be information included in the MLS printout, it could be answers on the Form 17, any information that the seller has provided to the buyer. If buyer discovers a material inaccuracy in that information, buyer can terminate the transaction in the first 10 days. So how does that protect seller? Because if seller has made a material inaccuracy, wouldn't seller be better served to let the buyer out of the transaction and sell to another buyer after correcting that information than to force that buyer to close the transaction and then suffer a lawsuit from that buyer after closing because buyer purchased a property based on seller's materially inaccurate representation? It doesn't make any sense that sellers would force buyers to purchase under those circumstances. If instead buyer has the benefit of the information verification provision and closes the transaction anyway, and then comes back to sue seller after closing, seller's defense says this: buyer, you had 10 days to determine whether the information I provided to you contained any material inaccuracies. And one of the big ones on this issue is the number of square feet in the seller's property. And I know that there's the blank down at the bottom that says verify the information, it's taken from county records or something like that. We still see lawsuits all the time from buyers against sellers alleging that the seller said the property has 3,200 square feet and in fact it only has 2,700 square feet. And so buyer sues seller. And after closing, seller's defense, if the information verification provision is intact, is to say, buyer, you had the right to conduct due diligence. And so you discovering this discrepancy only after closing or after the end of those 10 days means that you must not have conducted due diligence. Or buyer, if you did do your due diligence and you discovered the discrepancy, you closed anyway. It wasn't something that you determined to be a material inaccuracy. So why are you suing me now after closing when it wasn't material to you prior to closing or in your first 10 days when you had the right to terminate? That's how the defense works for the seller. So go ahead.
And here's the irony to the whole thing is that if a listing broker or seller is asking a buyer or buyer broker to remove the information verification provision, buyer brokers are more than willing and eagerly willing to do that because it protects them having that deleted. And that's the issue or the problem that listing brokers and sellers just don't understand. So when you ask a buyer broker to do that, they're happy as can be to eliminate that issue for them.
I agree with Paul that buyer brokers understand that the provision protects the seller, but I would be hesitant to say, buyer brokers, that it actually benefits the seller exclusively. I'm sorry, that there's no risk in your removal. I believe that there is risk to the buyer in you eliminating the information verification provision, and there is also risk to you in eliminating the information verification provision, because what if buyer does discover a material inaccuracy in the first 10 days, and based on your counsel, they've removed the information verification provision. Now they can't terminate the transaction, and their only remedy is to close and then sue the seller. Is that really a good place for the buyer to be? Particularly if they're there based on your advice that, oh, there's no harm that comes to you, the information verification provision benefits the seller only. No, that's not a good place for them to be. So Paul is right. The provision was written for the protection and benefit of sellers, and buyer brokers who understand that may counsel their buyers that the seller wants this, and this listing broker doesn't understand that this benefits the seller, so maybe you should go ahead and eliminate this provision.
But even if the buyer finds something after the 10 days, Annie, they're going to find other ways to get out of the contract.
Oh, really?
Yeah, there's plenty of outs for them to do that.
I'm not sure they can always find an out. That's why if they can
And
always
that's true.
find
They may not always find one, but they'll figure out a way if they can.
Yeah, if they can. But the reason buyers sometimes forfeit earnest money and lose earnest money is because they don't have an out. If buyers always could find an out, buyers would never ever lose their earnest money, and we know that some buyers do lose their earnest money. So that's not a risk, buyer brokers, that you can assume that the buyer is going to find a loophole or an out from the contract, because one may not exist. We draft the contracts so that they can't get out. We draft the contracts to create a binding agreement. So I think there's risk to both parties for the elimination of the information verification provision. I think that the listing brokers don't appreciate that there is risk to the seller. They don't understand. The listing brokers who suggest removal of the information verification provision make that suggestion in ignorance. And that's the really scary part of this situation.
Listing brokers asking for that paragraph or provision to be removed, is that detrimental to their client's best interest? And we haven't even touched on the fact that when you're removing boilerplate attorney-drafted forms, you are practicing law. And that's another issue to be for listing brokers to be aware of.
Yeah. When you fill in the blanks on the purchase and sale agreement, you are practicing law, and you're held to the standard of care of a real estate. You're held to the standard of care of a lawyer. And the Colton versus Heritage House Supreme Court decision that allows you to fill in the blanks on a purchase and sale agreement and holds you to the standard of care says that you are only allowed to fill in the blanks on standardized lawyer-approved forms. And so Paul's point is right on. The lawyers who draft your standardized forms, the statewide forms, believed it was important to include the information verification provision as boilerplate language. So when you choose to remove that from the standardized lawyer-approved form, you are replacing your discretion in the practice of law for the lawyers who drafted the boilerplate language of the forms.
And good luck with that when you go to court.
And good luck with that one when you go to court. Yeah. Anything else you want to talk about on this one?
No, I think that'll cover it.
All right, if you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.